Thank you for being here. We're here in our case 1CACV 210157, Edmonds versus 9540. Each side will have 20 minutes to present their argument. Appellant, you may reserve any amount of that time for rebuttal, but you're responsible for keeping track of your own time. We have the clock at the center podium for you to keep track. Because you're arguing from your table, you're welcome to walk around so that you may see the time. We are recording this argument, so when you begin your argument, please identify yourself and your client so that when we review the recording, we can keep everybody straight. The video recording of this argument will be on YouTube in a couple of days, so if you care to see how well you did, you can check there. We've read the briefs, we've conferenced the case, we've studied the law and the facts, so we're familiar with the case. When you begin your argument, just start out with what you would like to talk with us about. Counsel, you may begin.
Thank you. Kathy Samwise for the appellant Carol Edmonds. And I would like to reserve about 5 minutes for rebuttal. This court's memorandum decision in the first part of this case invited Mrs. Edmonds to resolve her dispute as to quiet title with this other party, 9540, and invited these parties, Mrs. Edmonds and 9540, to resolve their dispute as to quiet title, and yet the trial court summarily decided this case on summary judgment based upon this court's decision in the memorandum decision and made a summary conclusion that 9540 was entitled to quiet title and that my client was therefore not entitled to quiet title. And that violates this court's memorandum decision. That cannot be what this court determined in that memorandum decision.
Well, counsel, didn't we, in that case, our mem decision, we didn't express any opinion whatsoever about the merits of a quiet title action, did we?
That's correct. There was no determination as to quiet title.
So then why wasn't it just a blank slate for the Superior Court to take up the issue?
It should have.
And it couldn't have ruled on summary judgment?
That's correct, Your Honor. It should have been a blank slate, but instead, if the court, and I know the court has read the record, the trial court specifically relied on claims preclusion and also on issue preclusion to determine that 9540 was entitled to quiet title, and therefore to preclude my client from proceeding with her claim for quiet title. When this court's decision in the memorandum decision specifically found that Ms. Edmonds could not prevail on her quiet title claim against Cobalt, Arizona, because she hadn't named the party who was purportedly the current owner of the property, and that would be 9540. Therefore, this case should have started from ground zero, but did not. The entire decision from the trial court was based upon this determination that somehow this court had already made a decision as to quiet title. This court had not made a decision as to quiet title because, remember, this court determined that Ms. Edmonds could not prevail on her quiet title action because she had not named the current owner, and the other party in that memorandum decision, Cobalt, Arizona, had only sought dismissal, had not sought quiet title. And then the other point that this court made, that Your Honor, Judge Brown made in the memorandum decision, was that this court was not going to rule on the statutory defects, specifically because that would have been premature, because we didn't have sort of a winner. There was no way to determine who was entitled to quiet title.
So now we have before us the Judge Gertner's ruling. Aren't we obligated to affirm his ruling if it's correct for any reason? And along that, I'd like you to explore at least, or discuss with us briefly at least, why isn't this case controlled by Zubia, in which is the Supreme Court's decision that says, hey, if you don't get an injunction for whatever reason, and it has any connection with the sale, with the trustee sale, sorry, you're out of luck. What's the problem with applying that rationale here?
Right. So Zubia versus Shapiro is not applicable because in that case, there was a facial defect that could have been determined prior to the sale. So remember what happened in this case. There's a notice of trustee sale, and all the properties, parcels 1 through 11, including Miss Edmonds' property, parcel 4, was to be included in this sale. There was no way for anyone to know before the sale, though, that the improper party, that Cobalt, Arizona, was going to make a credit bid, and then the next day not pay the total amount of the bid as required by statute. So 33-811 requires that there be injunctive relief by 5 p.m. on the day before the sale. But if you don't know that there's going to be a defect in the sale, at the sale or after the sale, there's no way that the party could possibly enjoin the sale. What would be the injunctive relief? So
because she was aware that there was going to be a trustee sale, correct?
I believe, Your Honor, that she was aware, that she received notice of the sale, but there was no way based on that notice, and the record is somewhat unclear as to that. I know that the trial judge had asked her to amend the complaint to allege that she was not aware of the sale, but then in the memorandum decision it says there is a point made that she wasn't aware of the sale. So I think that's not entirely clear from the record, but even assuming she was aware of the sale, there was no way that she could have known prior to the date of the sale that there would be a defect on the date of the sale and the date after the sale. Because remember, 33-811 requires, and also 33-810, both of them require that only the beneficiary is entitled to a credit bid. So there's two separate statutes.
Counsel,
Yeah.
I'm sorry to interrupt, but your client's woes really begin much before all of this, correct?
That's correct.
Okay, and those, because we go through this whole factual history about how she pays for something and a title company sends money, and then the servicer does not give a partial release of lien. That all, your client doesn't dispute, she knew all of that well before the sale occurred, correct?
No, she did not. I do not believe she knew that. There's nothing in the record to suggest that she knew of all these defects. So Ms. Edmonds is, I believe, an elderly woman who is the trustee of this living trust. And I think that was part of the problem when she received this notice of sale. She thought she had paid $435,000 and paid in cash in full for this property for parcel number 4, and had no way of knowing at that point that it would be part of this sale. And so,
But that wasn't my question. My question was, by the time that the sale occurs, all of the predicate actions that gave rise to those sorts of fallout, that was all in the past.
correct.
Okay, so someone who was attentive to reading all of those things, reading the title documents, could have discerned that there wasn't a release prior to the sale occurrence.
That is correct.
Okay.
Although there sometimes can be, as my kid's pediatrician used to always say, sometimes two things can be wrong. And in this case, I would say there sometimes can be multiple things wrong. And in this case, that is true. someone presumably could have figured that out. But in this case...
But that's not what you're talking about here.
That's correct.
So you're talking about this defect that, we'll call it the bid defect, okay? What you're saying is that there was a defect in the sale because, or what your client is arguing is that there's a defect in the sale because the wrong party made the credit bid. Is that a correct?
Yes.
Okay. And that circumstance was not knowable to your client by the time the 33811C waiver time accrued. Is that correct?
Correct.
Okay. What in that defect, how is your client harmed by that particular defect?
Right. Well, because it was a statutorily invalid sale that failed to comply with the statutes, and under the patent case, the deed of trust statutes are to be complied with strictly, and there's a specific lengthy procedure for compliance with the deed of trust statutes. And so I think generally we as the public and trustors under deeds of trust are entitled to rely on full strict compliance with the deed of trust statutes.
Okay, so but we have here, and I'm aware of where the argument for the defect comes up, right? Your client's argument is that a creditor is the one who needs to make a credit bid. There are two entities here that have very similar name, and notwithstanding that, they're separate legal entities, and the wrong entity gets recorded as the one that made the credit bid. My question was, what is the prejudice your client specifically, personally experienced with regard to, because I know society in general has an interest in the laws being applied, but what is your client's specific personal prejudice from a defect in that occurrence?
Right. Yeah, no, it's a really good question, Your Honor. And I would just say that, again, we have an interest in compliance with these deed of trust statutes. It's a summary procedure as opposed to a mortgage. 33801 at SEC provides for this summary procedure for trustees' sales, and I think that anyone who is involved at all in a deed of trust is entitled to rely on strict compliance. That's what this court has said, and that's what the Supreme Court said in Patton.
But counsel, we understand the sympathetic nature of your client's situation, but your client was not harmed by the trustee sale. He was harmed by acts further upstream. So I don't understand, what benefit your client would get from blowing up the trustee sale.
Well, she was harmed by it because there was no way she could have known the day before, and so she could not have received or obtained an injunction. Cobalt, Illinois was actually the beneficiary, so there was this long series of conveyances.
But how would that have corrected her problem, which was a failure to get a release of the lien?
Well, so your question is, had the statute been complied with, would she have lost her property? Well, she would have, but now here we are as to 9540, and remember what Steinberger says is that a party seeking quiet title must always move forward and seek quiet title on the strength of his or her own title, not on the weakness of the adversary's title. So because there was non-compliance with this statutory scheme, the wrong party was able to receive the trustee's deed the day after the sale, and then 3.5 years later, after this litigation was filed, and indeed after the property was purportedly transferred to 9540, then at that point there was that corrective document, that so-called corrective caption that would have corrected the transfer from ALC to Wells Fargo, from Wells Fargo to the proper party. But at that point, 9540 should not have received conveyance because it received its conveyance from Cobalt, Arizona, which was not the proper recipient at the trustee's sale. And so if
Counsel, I'm sorry to interrupt again, but there was an argument in the briefing that isn't it possible that these entities could have been acting as agents of one another?
it's certainly possible, but there is no evidentiary record of that at all.
But your position is not that the creditor and only the creditor needs to be on the courthouse steps and the one voicing the credit bid. The creditor can send an agent to act on its behalf, to make that credit bid on its behalf.
Of course.
Okay.
But that can't simply be an argument of counsel at oral argument, oh, well, they were basically the same owners and it was an agent. We don't know that. There is no record of that. Again, this is a summary judgment case. And going back to Judge Brown's comment at the beginning, well, then, shouldn't we just start from scratch? Yes, that is true. That's why this trial court should have started from scratch instead of relying on claims preclusion. That court should have started from the premise, again, under Steinberger, and established law in Arizona and also in the Ninth Circuit, that quiet title is based upon the strength of that party asserting quiet title's own, the strength of their own title, not on the weakness of the adversary. And so what we've talked about now, and I do understand the court's point, well, how is Mrs. Edmonds prejudiced? But that only goes potentially to the weakness of her claim. And remember, this was summary judgment brought by 9540.
But counsel, what's the strength of her claim then? What is your point?
Right, well, it hasn't been developed.
Both, it's a weakness and a strength. What is the strength of her claim?
Well, first of all, that has not been developed. So immediately after...
But didn't it need to be developed because it was on summary judgment? I mean, wasn't it your client's...
She didn't bring a cross motion for summary judgment. There was no discovery.
But you have to defeat summary judgment by... So what material issues of fact are there then that should have been, that Judge Gertler should have addressed?
Right. So the material issues of fact would have gone to the strength or weakness of 9540's claim to quiet title. And there was no reason that 9540 would have been entitled to quiet title based upon this court's prior decision, because remember, in that original decision, Ms. Edmonds was not granted quiet title, but neither was Cobalt, Arizona, which did not ask for quiet title. So 9540 was granted quiet title based upon some sort of determination that Ms. Edmonds was not entitled to quiet title in the first action because she had not named the current owner. But now she goes back and names the current owner, or actually by this point, we're back in the trial court and the current owner has now filed a motion to intervene, filed a complaint, and she has now filed a counterclaim. But that's all, this is all summary judgment, again, filed by 9540. There has been no fleshing out of the facts. So we don't know what Ms. Edmonds knew. We don't know what facts would have supported her motion for summary judgment, and we're not asking for summary judgment in favor of Ms. Edmonds at this point. We are asking the court to reverse the decision to find that this case must proceed on the merits because there's insufficient evidence, there's issues of fact as to whether or not there were defects in sale, such that 9540 is not entitled to quiet title based on summary judgment. And I would like to reserve about 1:40 for rebuttal. Thank you.
Surely. Thank you, Counsel. Counsel?
Thank you. I'm Mark Drutz from Prescott with Musgrove, Drutz, Cack, and Flack, and we represent 9540. And just to immediately wade in on something the court asked opposing counsel, there's no prejudice whatsoever to Ms. Edmonds based on the fact that Cobalt Arizona bid at the trustee sale. Cobalt Arizona had the right to bid at the trustee sale. It's virtually the same entity as Cobalt Illinois, and it is the agent of Cobalt Illinois. And further, there was an affidavit, a Scrivener's affidavit recorded that the court considered Judge Carlisle, when the case originally was in front of him, considered indicating that Cobalt of Arizona was in fact the beneficiary of the deed of trust. That was talked about in this court's earlier opinion in this case.
Counsel, doesn't that, I mean, what do you make of the argument that that just raises a material issue of fact?
It doesn't raise a material issue of fact for the reason being that you heard opposing counsel say, which is absolutely correct, which is you need to have strict compliance with the trustee sale statutes. Mrs. Edmonds needed to seek to enjoin the trustee sale. She apparently overlooked the fact that the trustee sale included this particular piece of property, and she should have sought to enjoin the sale. Once she failed to enjoin the sale, she waived all defenses and objections she has to the sale, which includes this argument as to which entity bid at the trustee sale. The trustee sale statutes are absolutely clear, conclusive presumption. My client, who stands in the shoes of Cobalt, Arizona, and Cobalt, Illinois, received a deed to this property back in January of 2018. There wasn't even an amended complaint filed until April of 2018, and then Judge Carlisle ruled in September of 2018. How is it possible that Cobalt could have good title to this property, give a warranty deed to my client 9540, and 9540 not have good title to the property? It's crazy. There's no way that could be possible. This case is decided, as Judge Gertler correctly saw, on the issue of claim preclusion. The amended complaint that was filed in this case by Mrs. Edmonds back in April of 2018 had a count 12, wrongful foreclosure, in which she alleged all these same things. She alleged the wrong entity bid at the trustee sale. Then she said it again in count 13, which was her alternative theory, declaratory judgment, same thing. Then count 14, quiet title, she says the same thing. What happens? Motion to dismiss filed by the Cobalt entities. Count 12, which is the declaratory judgment case, count 12, which is the wrongful foreclosure case, is dismissed. Never appealed. Res judicata just on that. Count 13, declaratory judgment, her alternative theory, she appeals that one. What happens? This court affirms Judge Carlisle's decision to dismiss the declaratory judgment count. Count 14, the quiet title, similarly dismissed by Judge Carlisle, but first he gives Edmonds an opportunity to amend her complaint. Does she amend the complaint to allege that 9540 has title to the property? This is September 2018. We got title to the property back in January of 2018. She doesn't amend the complaint to make that allegation. Never even files a lis pendens. no list pendants whatsoever on the property. 9540 buys the property without even knowing about this litigation. After they acquire title to the to the property prior to the litigation, they find out that this litigation is pending. There were decisions made by Mrs. Edmonds in this case. She decided not to enjoin the trustee sale. That's got consequences. She decided not to file a list pendants on the property. That's got consequences. She decided not even to appeal the dismissal of the wrongful foreclosure count. That has consequences. It's res judicata. She decides not even to amend the complaint to allege that 9540 has title to the property now and should be brought into the quiet title case.
Counsel, don't you have at least a bit of weakness on the claim preclusion theory as to same parties? It's not the same parties.
It's privity. Privity is what's required. And privity exists in this case. Cobalt, Illinois, without a doubt, won the case on all those theories. Wrongful foreclosure.
But it didn't win on quiet title.
Oh, it won on quiet title in front of Judge Carlisle. Certainly did. He granted summary motion to dismiss on quiet title. Then it came up to this court, and this court affirmed. Now, you did say, well, you don't have 9540 in front of us. All you're doing is what courts always do, is you affirm on the narrowest grounds possible. You don't even need to get into the issue about the wrong entity bidding at the trustee sale when Edmonds makes a decision not even to bring in the right entity. There's no explanation why she didn't do that. And in response to your comment, Judge Brown, my client has title based upon Cobalt's title. And we just come back to the same argument. How can Cobalt have title to the property, and they unquestionably do, based on Judge Carlisle's decision and the fact that this court affirmed Judge Carlisle's decision for various reasons, but still affirmed, and 9540 not have title to the property? Could you imagine what would happen if this case went back?
Well, counsel, so is Ms. Edmonds' counsel not correct on her? She said that the trial here just based his decision on our decision. The court would still have to make the privity determination between Cobalt and 9540, correct? I assume that's what it did?
No, what Judge Gertler did is Judge Gertler was the presiding judge of Mojave County Superior Court. He obviously read the decision of Judge Carlisle. Judge Gertler's decision was just not based, with all due respect, on the memorandum decision that came out of this court. It was in fact based on specifically what was litigated in front of Judge Carlisle. And what was litigated, what was raised, was this entire argument you're hearing about today, which is the wrong Cobalt entity bid at the trustee sale. And what Judge Gertler did is he said, in fact, it went up to the Court of Appeals. Count 12 didn't go up, which is the wrongful foreclosure, which I think has a lot of consequences because they had an opportunity to litigate that and it was dismissed and they didn't appeal it. But the declaratory judgment count went up, which was based upon the wrong entity allegedly bidding at the trustee sale. That was absolutely affirmed by this court. And the quiet title count, which this court's well aware of, was decided just simply on the narrowest grounds, which was Edmonds. You didn't even bring the right people to court. The right people would have been 9540. So Judge Gertler's decision was based on more than just this court's memorandum decision. Furthermore, he looked at the whole issue of who bid at the trustee sale. And he based his decision in part, granting us summary judgment, on the fact that Judge Carlisle had a right to consider the affidavit to correct the Scribner's error, which this court addressed in its earlier memorandum decision. And he addressed the issue that, at worst, Cobalt Arizona was an agent for Cobalt Illinois and had a right to bid at the trustee sale. All of that was addressed by Judge Gertler in his extensive ruling granting the motion for summary judgment.
What evidence was there that there was an agency relationship?
Well, that was something that was discussed in the earlier case, wherein there was argument presented in front of Judge Carlisle by counsel for Cobalt, the Cobalt entities, where they pointed out in their oral argument to the judge that, in fact, these entities were virtually identical, but that Cobalt of Arizona was an agent for Cobalt of Illinois, and then the Scribner's error was corrected with the affidavit that was filed. And Judge Carlisle had the right to consider that, and that was taken up in the Court of Appeals decision, in which the court indicated that that wasn't an error for Judge Carlisle to have done.
Well, I just on that point, though, I'm confused. Either there was a Scribner's error, which means that the right party made the bid that was recorded incorrectly, or one Cobalt entity was the agent of the other. Those two, I mean, it all comes out in the wash, I suppose, but those aren't exactly comparable.
Well, it was, I understand what you're saying, Judge. It was decided on a motion to dismiss, which is what the Cobalt entities had filed in front of Judge Carlisle. I wasn't there at that time, but I read the record. I've looked at the oral argument that was presented. The argument of the agent was presented to Judge Carlisle, that Cobalt Arizona was an agent for Cobalt of Illinois, and the affidavit correcting the Scribner's error was also presented to Judge Carlisle. There was no question that Judge Carlisle was absolutely aware of this issue as to the alleged wrong entity bidding at the trustee sale. That's what the litigation was about, because the Mrs. Edmonds, not having sought to enjoin the trustee sale, couldn't argue that, well, the property arguably should not have included this property as part of the trustee sale. That was waived. So the only possible argument she had was the wrong entity bid at the trustee sale, and that issue was considered by Judge Carlisle on a number of counts that I've gone through, and then it went up to this court, which affirmed Judge Carlisle's decision. And then the very interesting point that this court raises, which is, well, where's the harm to Mrs. Edmonds that Cobalt of Arizona bid instead of Cobalt of Illinois? And the answer is, there's no harm, there's no prejudice. All it is an excuse that opposing counsel raises to try to attack the trustee sale.
So there's been no allegation that the credit bid was lower than it should have been because of a different entity, or any sort of discrepancy or anything that could have been at least arguably a benefit to the Ms. Edmonds?
That's absolutely correct, Judge Brown. All they have, their entire case, is just simply based on, and this is from Judge Carlisle all the way up till today, is, well, Cobalt Arizona bid instead of Cobalt Illinois. Not that they bid a penny less, not that Edmonds didn't get credit for it, it's just the wrong entity allegedly bid. And that was addressed by Judge Carlisle, as I pointed out, on the basis of the agency, argued to Judge Carlisle, and I think we've cited part of that oral argument in our brief, and the fact that there was this affidavit recorded. But there was no harm, no prejudice whatsoever to Mrs. Edmonds by the fact that Cobalt, Arizona bid on the property and not Cobalt, Illinois. The problem that the plaintiff Edmonds has is that they can't really get around claim preclusion because it was all litigated before. These same issues litigated before. How could we send this case back and give it a clean slate? Are we just going to ignore what Judge Carlisle did? Are we going to ignore what was appealed and what was affirmed? I mean, how would it make any logical sense? We're now going to have to bring in Cobalt because they breached the warranty in the deed that they gave to 9540, and Cobalt's going to be back in the litigation saying, well, the court's already determined that we've got good title to the property. Why are we back in the case? It doesn't make any logical sense. And all of the trustee sale statutes are against Mrs. Edmonds. Her failure to seek to enjoin the sale means that any objection she had to the conduct of the sale under 33-811 are waived. It's all waived.
Counsel, does that, as counsel for Edmonds has pointed out, include those items that are not knowable at the time that deadline accrues?
Judge, with all due respect, I think it includes everything. I didn't draft the trustee sale statutes, the legislature did, and they said all defenses and objections. They said all defenses pertaining to the conduct of the sale, and this has to do with the conduct of the sale. The trustee has a lot of discretion at a trustee sale. The trustee has a right to accept the bid from whoever the trustee determines to accept the bid from. Any complaints that they really have should have been addressed to the trustee, shouldn't even be in a quiet title or a wrongful foreclosure declaratory judgment case. They waived all of their defenses to this trustee sale because they didn't seek to enjoin the trustee sale. But if we want to look at it more expansively, they don't even have a reason that they can raise to this court as to how Ms. Edmonds was harmed or prejudiced by the fact that Cobalt, Arizona bid instead of Cobalt, Illinois. They're raising it for one reason. It's a red herring to try to get this court to reverse the summary judgment and not uphold the trustee sale that's already occurred.
Counsel, would you agree that there could exist in these types of cases at least an argument for equitable remedies, like the Crone case from the early 2000s where Supreme Court essentially invalidated a sale because it was the bid was grossly inadequate? Do those types of claims still exist today in light of the strong language from the statute on the injunction, on getting an injunction? Is there a possibility, basically, what I'm saying, for injunctive or for equitable relief, and has that even been pled at all here?
No, it hasn't been pled. And certainly, I think if somebody does a trustee sale and somebody bids less than 10%, I think that was perhaps the number thrown out in the Crone case. Someone could seek to invalidate the trustee sale on that basis. But I don't think that this court should be saying that we're going to invalidate a trustee sale because Cobalt of Arizona bid instead of Cobalt of Illinois, when in fact all of that's been litigated before we walked into court today in front of Judge Carlisle and earlier in the Court of Appeals ruling affirming it. And the fact that Edmonds made a lot of decisions that I'm sure she wishes she could do different if she could. But she didn't enjoin the sale. She didn't name 9540, which is beyond me why they didn't do that. then they would have at least had it in front of them, and they didn't record a list pendants. All of those things are absolutely fatal to Mrs. Edmonds' position. So I certainly think, yes, maybe Judge Brown, certainly under Crone, if there was disparity, a huge disparity in the sales price, that might be grounds. But that isn't our case. We got to live with our case. And our case doesn't say anything about that. It's just Cobalt, Arizona bid instead of Cobalt, Illinois. Their claims are defeated by claim preclusion, their own poor tactical decisions, and the Arizona trustee sales statutes, which are against them.
Thank you, Councilman.
Thank you very much for your
Appreciate
time.
your argument. Rebuttal?
Counsel said multiple times that the violation of the statute is an excuse, that it's a red herring. But we are a nation of laws. We have this strict statutory scheme. And as Judge Brown said, he said something about, well, there's strong language of the statute on injunction. That's right. But there's also strong language in section 33811A and 33810 that require that only the beneficiary of the deed of trust be the party to submit a credit bid. So why is it that this provision on you must obtain an injunction prior to 5 o'clock on the day before the sale, why is that statute more important than these two statutes? This statutory scheme says the same thing twice. Only the beneficiary is entitled to make a credit bid. And then as to the argument that, well, it's basically the same company and it was an agent, and then was it a Scrivener's error? As Judge Howe pointed out, well, what was it? Was it a Scrivener's error, or was it an agent relationship, or was it basically the same company? That is not something that has been fleshed out because, again, there has been no discovery on this issue. And so I would ask that the court reverse summary judgment and send this court back, send the case back, remand for further proceedings. Thank you.
Thank you, counsel, for your argument today. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned. Thank you.